Okay, we're live. Okay, good morning. This is the New York City Board of Standards and Appeals Public Review Session for April 6th, 2020, 10 a.m. session, which will be followed by a public hearing. The cases to be heard and adjourned and postponed are 24708 to be adjourned and postponed, 24708 BZ, 34312 BZ, 55137 BZ, 334878 BZ, 7204 BZ, 2019-90A, and 2017-34 BZ. These will be postponed or adjourned.
Okay.
The cases to be heard today are 11594 BZ, 24503 BZ, 6414 BZ, 12295 BZ, and 21835A. Okay, so do you want me to call the adjourned or postponed, or you want me to start with the regular cases?
Well, you already listed what is adjourned and postponed, right?
Yeah, okay.
Okay, yeah, I just want to say the reason for adjournments in certain cases, or let's say postponements in certain cases, was because we didn't receive notice of I think this is important. We didn't receive notice of hearing in time, and it is the applicant's responsibility to provide us with notice of hearing immediately after they serve it. And if we don't, especially under these conditions, if we don't have it in our folders at the time that we're reviewing these cases, the case will be adjourned. And we cannot undo the adjournment because announcements have gone out. It's the responsibility of the applicant to get proof of service and proof of notice of hearing in on time, and it's not our responsibility to chase after the applicant to do it. So please, all applicants listening, take note of that. Okay, so I think we can start with the 10 a.m. calendar because you already read which ones will be adjourned, right, Tony?
Yes.
Okay.
Okay, so the first case is 11594 BZ, 2470 Bedford Avenue, Brooklyn. 11594 BZ. That's a continued hearing.
Okay. Okay, there was a chart provided that purports to establish continuous use. So we had a submission on this. I don't understand what it is. And there isn't any supporting documentation. So I actually didn't understand what it was supposed to be showing us. We had simply said, show us exterior Google Street views that cover the time period, and that would be enough if we see the signs and active use on that street. And they didn't give us that. Instead, this confusingly not useful chart was provided. Photos were provided that the tires were removed from the walk. Please mute. I'm hearing, thanks. Photos were provided that showed tires removed from the sidewalk, signage reduced, and no parking signs that are placed on little stanchions on the sidewalk, so to discourage sidewalk parking. Based on the photos, the site now looks actually very good. So the question really is how to keep it like that, because it has been not a cooperative property operator up until now. There is a dumpster that's shown in one of the photos on the side of the building. I'd like to know whose that is, because there had been issues about dumpsters being stored in front of the site. So whose is that? And they need to, they stated that they applied to the Department of Parks for street trees. They should show us proof of that. And yeah. Those were my comments. So I'll recognize Commissioner Shanda. Just a sec. Yeah, here we go.
I had similar comments regarding the continuous use document that was provided. The chart is inadequate. It should be backed up with supporting documents and photos preferably, if the documents are not available. I also was looking at the applicant's statement that the tire racks will be permanently placed and relocated inside. I'm glad to know of that statement, but I would like to know how that is going to be done. Interior photographs have, the plans show that the tire racks would be inside, and there's a note that says it would be affixed to the floor or any wall. I think these tire racks are not backing up against any wall. It is just kind of freestanding, so it has to be then affixed to the floor. And I just want to make sure that the note is consistent with what they're planning to do. And if they have already moved the tires indoor, I would like to see a photo of that.
Okay. And
with regards to the signage, the calculations indicate that the signage meet the requirement. And the diagrams also show it. I don't know if they have modified the signage the signage in actuality. So if they have,
the photos show signs came down from awnings. There's only signs now, like they match the diagram.
Okay. All right. Thank you.
And Commissioner Otley Brown.
Okay. I wanted to talk about the operations of the site, because not only did the community complain that the cars are being worked on in the street and that there were cars without license plates parked on the street, but the police department also said that the applicant was definitely the offender in terms of all of the cars without license plates that were parked on the street. The applicant attempted to address this by saying that they put bollards up to prevent cars from driving on the sidewalk, and also said that customers are brought immediately into the building and no cars are allowed to park on the sidewalk or on the street while awaiting servicing. But how can they guarantee to us that they have rectified the situation that the police department speaks of? That's what I need to know.
Right. That's it. How do we make sure this is the case going forward? Right.
Yes.
Okay. Thanks. Commissioner Sheta. Oh, okay.
Thank you, Chair. I share the same comments regarding the continuous use. I believe what we asked for was evidence, not just explanation. What's provided is just like the information without any evidence. The chart is not an evidence. Other than that, I believe that the photos submitted are, I would say, they are irrelevant. We all know that everybody is staying home. There is no actually activity. So I'm not sure, when we're business as usual, what is the status of this operation is going to be. So I would be suspicious about the pinky pictures that were submitted. The other things, the racks, yes, the racks were removed from outside, but I would like to get pictures for permanent racks inside. Pictures showing that they have installed permanent racks, something that's affixed to the concrete floor or to the wall, something like that, that give us some sort of confidence that, yes, we're going to keep the racks inside. We're not going to move them back once we get that application done or granted. That's all. Thank you.
Thank you. Sorry, trying to unmute you. There you go.
You want to ask me first? Thank you. I too couldn't make heads or tails out of the continuous use submission. And yeah, frankly, there was a lot of issues with this applicant. It seems like they're trying to make take these steps, but I too wasn't satisfied that this in and of itself is enough to put me at ease with regard to the complaints that the community had and the complaints by the police department. I'd like to see something more and you know, we run into this problem often enough where what else can we, what could they give us? But all I can say is right now I'm not satisfied.
Okay. Thank you. Okay, next case.
24503 BZ, 160-11 Willets Point Boulevard, Queens.
Okay, this case was, just so people have it corrected on their calendars in case they didn't, this case was last heard in November, on November 26th, and adjourned twice since then.
Right.
So the notation on the calendar is incorrect, but it's been corrected on the lineup. They did show, as requested, the acoustic fence on the plans adjoining the residential property. They seem to have dropped off the sign that we talked about a long time ago that used to be on the plans indicating where the additional overflow parking is. There used to be a sign that indicated, you know, pull through here to go to additional parking. That's no longer shown on the drawings. The planting bed width is not indicated on the site plan at BSA 11. There's only one width shown. That's where it's something like 10 feet. It doesn't show how wide it is where it necks down. And there's an area labeled for section BB on BSA 11. What is the landscaping situation in the balance of the 10.9-inch planting bed? And it's not clear that all of the other landscaping that's shown that's up against the building will be placed in planting beds, since there is no sectional detail there. And the specification charts state that those plants are in containers. So that could either be, and we've seen that they buy, 400 containers and they set them down. These have to actually be planted. I know a lot of plants are supplied in containers, but it's very unclear because the drawings don't tell you that that's a planting bed adjacent to the building. So they need to provide a planting bed detail for that area as well. I just thought the kind of the corrections to the plans were quite sloppy, in that they know that we're focusing on this subject, and they didn't really look carefully at all of the issues. I find this often the case with the McDonald sort of architecture firm or engineering firm that does this. They only care about the McDonald standards, but they don't really pay attention to the standards that have to do with adjacent properties and the effect of McDonald's on adjacent properties. They need to pay better attention to that. Commissioner Shanda?
I thought their explanation and justification for all the changes that they're proposing and what they can or cannot do was reasonable. And I really did not have any further comments on this project.
Okay. I think with respect to that has to do with continuing the planting all the way over to the end. Right.
Yeah.
They have this level change, which we didn't realize.
Right. And they're providing the acoustic, some kind of an acoustical fence. That was another. So I think those were my two primary concerns, but I didn't look into the details with regards to the landscaping. So yeah, I'll defer to you on that.
Sure that we'll get what we expect, and they didn't detail that. So, Commissioner Otley Brown?
I was satisfied that they were putting the acoustic fence along the northern fence, which will reduce the sound by, I think, 28 decibels. And I was fine with the landscaping from the last hearing. So I don't have any additional comments.
Okay, thanks. And Commissioner Sheta?
I don't have any comment with regard to the landscaping. I'm okay with stopping the landscaping before the area where that retaining wall exists. They are talking about if they install trees, they're going to be shorter most likely than the retaining wall plus the fence, and I buy that. But during the last hearing, the last time I would say we heard this, that was like 11/26/19.
Mm-hmm.
I had a conversation with their consultant, and I asked him to give us predictions for the sound at the top of the fence.
Yeah.
that wasn't provided. I was like crazy talking to myself. Did you really ask for this? And I actually went back to the video and I listened to it. And yes, I did. And again, what is submitted this time is just the predictions, not even the readings, the predictions. And they are like at the level of the microphone if I'm not missing something. So this is one thing. The other thing, if you look at the two submissions for the sound propagation, I couldn't see any difference other than just cropping what is beyond the fence. This submission, I looked at both. I'm not sure if I'm missing something. But if you look at the two diagrams, the one that's submitted before and this one, they seem to be the same, but just crop what is outbound from the fence. So I'm not sure what is the point here. It either say we didn't do readings, we cannot do readings, and we believe it's gonna be okay. We could put it under testing. If somebody complains, I'm okay with granting this, but if we get complaints, we'll bring you back.
Mm-hmm. Right. Okay. Yeah, it's true that on that other case we had, we saw that the sound spilled higher than the fence. And so they adjusted the design of the ordering the contraption into which the speaker is mounted. They moved the speaker inside the enclosure, and that changed the direction of sound. And so,
Diet Castle case, right?
yeah, sorry?
Yeah.
So, and we haven't seen that here. Here, there's an assumption that that the sound won't propagate higher than 9 feet in height, which is the fence, and without any backup. And I have in my notes also that we asked for sound propagation in section, not just
Yeah.
and give it to us. Yeah.
We initially asked for a section, and then at the very end of the hearing, I was talking to their engineer. I said, listen, you know what? If you give me something that says this is at the top of the fence, and I see that there is no significance, we'll let it go.
Mhm.
But again, what we got is at the level of the microphone, and all what they did is just to crop what is outside the fence.
Right.
If you compare the two charts, I believe, I'm not a sound engineer, but I looked at him, I put them side by side actually, and I looked at him pretty much the same, but just widening what is outside the fence.
Right. Okay. Okay, thank you. And Commissioner Shibeta.
I'm glad that Commissioner Sheta brought up the sound attenuation. We did speak about that a lot at the last hearing date. I too was surprised not to see any notes about what would happening at the level. That's my major issue with this.
Mhm. Okay.
And I do believe we asked for actual readings. I'm not sure if we're backing up from that, but I do believe we asked for actual readings.
So what I don't remember, and maybe Commissioner Sheta, I'm going to unmute you in case you could tell us, was whether they're installing a new sound system, and so therefore readings only work once they install, or whether this is the existing sound system, because they're doing modifications where they may be moving the equipment since, right? Remember, this is the one that has a difference in the driveway. And so that's why now the planting is over where it is. Before, the driveway was close to the building. So I think that this isn't set up yet, but I could be wrong. I'm just not really sure.
Actually, my understanding is that the sound system is in place. If it's not in place, I'll back off from asking for actual reading. But the idea is, even if we were confused about the actual reading, we did ask for something at the top of the fence and we didn't get it, and that makes you very suspicious immediately. If you ask for something and you don't get it, and you get something actually that you got before but with some touch-ups, insignificant. I don't know why. I mean, we're not looking at something that's a big deal. if you have an issue with sound, it's much better to fix it today than coming back later. If you come back late, come back later. It's gonna be cost on you.
Right, okay. I'm seeing Commissioner Shanda had her hand up.
Thank you, Madam Chair. I am looking at the existing plan that was submitted back in January of 2019. And yes, the proposal is to change the orientation of the drive-through and also therefore the location of the sound box because right now it comes in at an angle, and it is going to be at the recommendation of the community board was to kind of straighten it out. And so that would require the sound boxes to be relocated from the current location.
Okay, thanks. Okay, so now we have that. So it would be a modeled analysis. And we did ask for that. I have it in my notes, and that's what we've been consistently asking for on all of these applications. So, okay, thank you. Okay.
Next case.
Yeah.
6414 BZ, 1320 East 23rd Street, Brooklyn.
Oops, sorry. Okay. I thought I was pretty clear. Let me just make sure I'm talking about the right one. 1 second. 1320 East 23rd Street, right?
Yes.
I thought I was pretty clear about how this case should move forward, that the request to extend the permit should include an amendment to the design of the house that increases the side yards to comply with the zoning resolution and 50% retention in existing building to prevent demolition of the house, since no work was done at all and no permits pulled based on the 2014 approval. And given the financial constraints that the owner has faced in the last 6 years that prevented any activity at all on the project, including obtaining permits, and now the changed circumstances on the planet that will likely prevent further activity in the immediate future. Instead, we received only a letter from applicant's counsel stating that the tests in Putnam that relate, in the case of Putnam, that relate to vesting of a permit, whether such vesting is retained, don't apply in this case. The 2 extensions of time to complete applications that applicant cites as examples of being that applicant should be allowed to continue predated this board's approach to these applications, so are not relevant. Applicant knows very well what the history of these permits is, and knows very well that the board has clarified the standards under which these permits can be approved. To not waste any more time, I would direct the applicant to do as instructed and amend the application, mindful that I'm not saying that the application has to be refiled as new, but that the project has to be amended to comply with the standards that have been in place for at least the last 4 years. So that was an instruction. I'm very surprised to see just a letter saying, no, we don't feel like it. If the applicant wants to move forward, they need to make those changes. I also just want to say before I move on, Patrick Miller is in the waiting room. You need to hang up. This is a review session, and we will not recognize you, and you should hang up the phone. Nobody should call in during review sessions. So please hang up the phone. Okay. Sorry. I'm unmuting Commissioner Shanda.
I have no additional comments.
Okay. And Commissioner Otley Brown.
I have no additional comments.
Okay. Commissioner Da?
Yeah, I agree with you, Chair, on what you said. I don't have additional comment. The only thing I would say is that they talked about Putnam and they made the test and they concluded that, yeah, because the other case was like 15 years. We forgot about for 15 years. This one is just 5 years. The other one is different, so it shouldn't apply to us. I would respond to that just to put in the record that the applicant shouldn't benefit from being reluctant not to construct by getting something that if somebody's applying today is not going to get. So I strongly agree that they need to file for an amendment or consider amending the special permit to abide with the new standards that the board apply these days.
Okay. And Commissioner Shabeta.
Nothing further from me on this, Chair.
Okay, thank you.
Okay, new item 12295BZ, 15265 Rockaway Boulevard, Queens.
Okay, we have proof of service of initial application and of notice of hearing to officials. Community Board recommends conditional approval with 6 opposed. They state the motion to accept the application with conditions, and I'm just reading what they say, so I don't totally understand it. The Sunday operating schedule of the warehouse should be closed from 7 a.m. to 7 p.m. with a 5-year term and local labor hiring, which is not really related to us. I don't understand what they mean by the Sunday closure from 7 a.m. to 7 p.m. because that means it's closed. Unless it sounds like it's closed on Sunday. So I'm not really sure what they're getting at. And I think the applicant or I don't know if there's anyone to call at the community board, but someone should find out what they meant by that. Since the requested 24/7 operation, 24 hours, 7 days a week operation is a significant change from what was previously approved, adjoining neighbors should be notified. So we need to send out an example of a notice of hearing to the neighbors, and this way it'll be put on for a hearing that'll be a Zoom hearing, a teleconference. So that will enable more neighbors to participate, even if by the time this is scheduled, we're not having the hearings this way. I think this telecommuting option of joining a hearing is an excellent way of improving community input. So we'll continue to do that. My principal concern is with the neighbors adjacent to the parking and open loading area, since they aren't shielded by the building structure the way the houses are that back right up to the fairly tall one-story structure. So we need more information on what is going on in the lot line, though they did provide us with a lot of photographs. One house shown in photograph 4 in the neighborhood character study has windows facing right into the parking area. So that means middle of the night deliveries and trucks pulling into the loading docks could be very disturbing. I'm wondering whether it's possible to have their operations only use from, say after 8 p.m. until whatever, 6 a.m. They only use the loading docks that are on Rockaway. Maybe that's a way of reducing the annoyances to the neighbors. View number 9 also shows dumpsters adjacent to the residences, and they're not in an enclosure. They're not shown on the site plan. Among the conditions of the prior approvals were that trash was to be stored inside the building until just before pickup, and that dumpsters, it's a little hard to understand what they meant by this, but the dumpsters were to be stored on the interior, quote, near the wall of the interior loading bays. And since the loading bays have access from Rockaway, it seems to me that that meant that they had to be on the interior someplace in the loading bays. And which means also that when there's trash pickup, the trash pickup would be from basically what's the sort of noisy commercial route as opposed to adjacent to the residences. There's a mention in the neighborhood character study about trees in the R3X. there is planting in this kind of little wing at the edge of the site, which is labeled an R32. Actually, the drawings are not up to date with, or not correct about what the zoning district boundaries are. It's actually this site itself sits in an R31 with a C22 overlay. The site adjacent is an R3X. So the plans are wrong about the zoning district boundaries, and that should be corrected. So for me, I think if we're to think about a 24/7 operation, then the buffering to the parking area has to be much more significant. I can see that the prior board who approved this were very conscious of the impact of this use on residences, which is why they created sort of that little forest in that one small area, which backs up directly to a residence, to not allow that to be used for any kind of open storage or anything. The view 21 also shows an unplanted planting bed. And the applicant cites another warehouse a block from the subject, for which the BSA allowed a 24/7 operation. That site, however, shares a lot line with only one residential building, it doesn't back up against 10, but this is actually backing up against more than 10 houses because it wraps around to the corner. So it's more like 15 houses that are affected by this, and it's all residential. So it's a very different situation. And I personally understand that if the way of warehousing in this area is 24/7, and in order to continue a business, you need to do that, I don't object to the idea of 24/7, but then a significant work has to be done on the open lot to make that viable, in my opinion. So now Shonda?
I think my comments are very similar to yours, Madam Chair. So if I'm repeating, I'll try not to. First of all, a couple of corrections. The statement of fact states incorrectly the count of loading berth that was required back in 1996. The historical background and the conditions that were applied in 1996 and 1999 need to be clearly identified. In the description, the applicant did not refer to any of the 1996 conditions. Specifically, these conditions continue to remain, and they were applicable, like the hours of operation, garbage storage, dispatcher, landscaping, etc. I would, though, as you mentioned, that this is a question I have regarding the continuity of use. Do we need any document regarding the continuity of use? I mean, the site is vacant, but I just wanted to throw it out there if we needed to. If the lease has expired, that is, as of end of 2019.
Mm-hmm. Right.
Chase has a question.
So based on the expiration of term in 2016 and their filing date in 2019, they do need to go through the waiver findings of our rules 1 through 7 for applications that have been filed more than 2 to less than 10 years expiration of term. So they should go through those findings as well. Yes.
So Case, you broke up when you were citing the section can you say what the rule section is again?
It's BSA Rule of Practice and Procedure 1-07.3 subsection B2.
Okay. So
Thank you.
Yeah, okay. So it is proof of continuous use and serious loss that would occur if the use could not continue.
Right.
Okay.
With regards to the warehouse use, I was at the site yesterday, and of course, it's not the best of time to analyze anything, but just to get a sense of the location of the place in relation to the residential uses abutting it. And I agree with you, Madam Chair, that should we allow this extension of use and change the hours of operation to 24/7, only the loading bays fronting along Rockaway Boulevard should be allowed to be operated beyond the 7 p.m. hour time, and also on weekends. And the ramp that leads into the parking garage for loading, those should be allowed. None of the loading bays that are fronting the parking lot, abutting the residential, should be allowed. Now, the applicant, there isn't any landscaping that is located within the site. Whatever overgrown that has happened has been on the residential side. There is a fence. It is not 100% opaque fence. And I think we should recommend, we should ask for a much more solid residential type fence, like a PVC fence with some kind of an acoustical barrier. Because any kind of operational noise, vehicles coming in and out, vehicles, when they're pulling out, they make this backup noise, any of those noise that potentially can generate, and the parking lot that is located outside, I'm assuming, are being used by the employee. They're going in and out. If there's a way to prevent any vehicular parking on the parking lot during after hours, and all employee parking should be indoor to minimize the amount of the open parking area being used for any staff parking, employee parking, visitor parking, or even loading and unloading, to minimize the amount of noise that could be generated from vehicles backing in and out, employees talking, all of that. Similarly, lighting. We need to know the lighting plan, what kind of lighting, lumen spread, and that should be kept to a minimum. If possible, if there is space, I would recommend that they try to provide a little bit more. Once we have a solid PVC fence with an acoustical block, maybe we don't need landscaping, but there is a portion right in front of the Rockaway Boulevard. There's a triangular little piece of a space next to the ramp that could be beautified. It could be like little shrubs, nothing more than that. It's right now vacant, so it's something that will collect dust. It could be landscaped, or you could provide benches there for people to sit. If the staff wants to sit outside and come and smoke, maybe that's a place to come for them to do that. So I think these are various ways we can try to allow an operation, a change in this industry that we are noticing. Allow that, at the same time be very mindful, as you said, of the impact that it may have on the neighborhood, and require a higher standard of protection and buffer from between the residential and this use, especially the parking lot.
Right. Okay. Thank you. I just want to add that when I was saying a more significant, I didn't mean just a fence. I mean significant landscape buffering between the residences. So, which is what we've seen in some other cases where you build something that's like a 15 to 20 foot deep buffer zone, where now you're growing some serious trees and all of that. Because I'm thinking about the house that's next door that has its windows looking down at this, and it's seeing trucks going all the time. And, how do we regulate actually the trucks coming in? We can say you can't use that for trucks, but now it's the neighbors having to call us and say they're not in compliance. So we say both, you can't use this side, but just in case you do, and you shouldn't, at least we have like belt and suspenders with buffering.
We should then require an operational plan and the breakdown of how many employees, because I think most of the parking space is being used by the employee and visitors. So we do need to identify that because that may take away the employee parking, and that can be another issue. We do not want to have that compromised. The other thing is also maneuvering, because there is a possibility of a large trailer that can enter from the parking lot and can park along the side of the building. I don't know if there is a way to minimize that and make those smaller trucks and have more of the trailers loading and unloading from the Rockaway Boulevard or from within the building. So we do need a little bit of an operational maneuvering plan just to see how the vehicles are coming in and out and what would be feasible and durable for the residents.
Okay, Okay, thank you. I'm going to Commissioner Otley Brown.
I think that the 24/7 proposal is reasonable, providing that the outdoor space is significantly buffered and isolated from the residences behind. I'm not sure of whether or not it should be in landscaping form unless it's significantly large trees, because I feel with truck maneuvering, any little low bushes are going to get run over.
Mhm.
So those are my thoughts. I think also that in the evenings, they should take great pains and overnight to avoid using the parking spaces and the loading zones that are within that parking lot. And they should consider moving the yard lights that are on the poles that are actually on the border of the lot lines with the residential, move those in towards the building. And also we need the proof of continuous use. Oh, and in addition, I'm thinking that the community board's request to be closed from 7:30 on Sundays is in response to the 24/7 proposal, in that it's probably the Christian Sabbath day and they want less movement in that area during that time.
So they're saying, no, you actually can't be open on Sunday.
From 7 in the morning till, I guess, what did they say? I gotta open that to see what my notes said. From 7 in the morning until 7 p.m.
Yeah. So they're saying no to Sunday, basically.
Right.
Right.
Mm-hmm.
Right. Okay. All right. Thank you. For any other comments? That's it? Okay, thanks. Commissioner Shetta.
Thank you. I do share the concerns regarding the noise, I mean the lighting. I also have issues with the noise that's going to be generated overnight if we allow 24/7. The applicant explain to us how he's going to mitigate that. In addition, I can see, I'm looking at the Google view, and I did read the statement of facts, and in their statement, they are talking about that all loading activities occur from Rockaway Boulevard. I'm looking at Rockaway, the view on Rockaway Boulevard now, and I can't see any loading docks there. I see like big doors. I'm not sure if what they meant is that the truck is going to get inside and load and unload. I don't know.
No,
but
if you look at the floor plan, those
yes,
are interior docks. So you actually do go through the big doors, and the docks are on the interior, whereas the ones in the parking lot are exterior docks where you back up against the wall and you load directly from the outside.
yeah, I see that, the first floor plan. Yes.
Yeah.
If they do not need, my concern is as far as they have the docks that are open to the parking lot, you cannot guarantee that trucks is going to get in through the parking lot and load and unload from these docks. And if this happened, I believe, considering the very close proximity of the houses, it's going to be a nightmare to the owners of these houses. So we need to be very careful about that. They are asking for term elimination. I don't know what is the reason for that. I want to get explanation why they want to eliminate the term. What's wrong with a 10-year or 15 or 20-year term? And so we can have a chance to bring him in to check on him if they do not comply. Proof of continuous use, yes, I believe we need, and we want to make sure that the neighbors are notified and they are engaged in this process.
Mm-hmm. Yes. Okay. Thank you. And Commissioner Shibeta.
So I had many of the same comments as the commissioner before me. I do on third or fourth, the need for proof of continuous use. I would like there to be service notice sent to the neighbors in the rear, or
Uh-oh,
He's freezing.
yeah. This is what happens. Commissioner Shabeta, if you can hear us, you have to dial back in. Okay. Sorry. We have a frozen commission. I'm going to text him just a second. Mm. Oh, he hung up, so he's doing it.
I'm gonna call back in.
Okay, thanks. Actually, that's another way we can do it with a phone call. Yeah, I think this is Commissioner Shabeta on his iPad. Is that right? Is that Commissioner Shabeta on his iPad? Hello? I'm going to try one more time. Maybe he can give testimony on the phone.
Sure.
Hi, I don't know if you dialed back in, did you?
I'm trying to get back in.
Okay, why don't you give your testimony? I think everyone can hear. Yes, everyone?
Okay, sure. I think it's reasonable to follow the committee board recommendation on the 7 a.m. to 7 p.m. I would like to have notice sent out to the neighbors surrounding the premises. I think that with this type of use, I wouldn't be comfortable approving 24/7 use unless we've had a resounding chorus of neighbors saying that they're so respectful to the residents here.
Okay, great.
And I think, as others said before me, naturally, I think that we should have evidence of continuous use.
Okay, great, thank you. Any other comments on this one? Okay, so I'm going to keep you on the phone and you try to keep trying to dial back in, okay? But I need to announce, so excuse me because I'm speaking loudly over you. There are 3 people in the waiting room. Kurt, can you show again that sign? You need to hang up. This is a review session. We will not admit anyone in the waiting room. Please hang up your phone. Okay. Okay, you see the sign showing on the YouTube video. This is a review session. We do not admit anyone to speak during review session. Okay. Okay, Tony, we can move on.
New case, item number 5, 2018-35A, 22 Van Street, Staten Island.
The hearing notice that was provided to the applicant did not state that there are hearing notice requirements for appeals of the building code. However, BSA rules 106.5A states that notice to the agency issuing the final determination should be given. And I don't see anywhere in the submission that this was done, but that may have been a misunderstanding from our own direction. There is, however, proof of service of initial application to officials, which includes the buildings department, and the buildings department is kind of the agency being contested here. It's their final determination that's being contested. I think there are a number of defects in this application, not to mention that it was first filed in March of 2018. Notice of comments issued that April of 2018, and no response to them until last summer, and then only calendared for hearing 2 years after the initial determination by DOB, I assume because of notice requirements and getting a proper final determination, the original one of which came from a plan examiner. That's not a final determination. So and it also didn't cite the sections in the building code that were sought to be varied. So I frankly don't know how serious the applicant is about this application. First of all, the applicant does not cite or quote the relevant standards governing the board's authority to grant a variance of the building code. For that authority, they need to start with the city charter, then go to the construction code's general administrative provisions, and then the building code, and include all relevant citations, since we see very few applications for building code variances. Okay, just 1 second. Commissioner Shabeta, are you online? Yeah, I'm hanging up.
Second.
Okay. Okay, welcome back. Okay, I see 2 people in the waiting room. You need to hang up. This is a review session. Hang up the phone, please. Okay. Second of all, there is no indication that the applicant went back to DOB after this denial to find out what it would accept as additional work to make this office use possible in this wood frame building, and instead assumes that the only solution is demolition. Third, there is no submission indicating what work would need to be done to comply with whatever are the relevant sections of the building code. The applicant states that DOB's response is contrary to past practice without providing any examples of this. This application really looks to me to be an attempt by the applicant to have this board walk it through the building code and determine which codes apply and how the work should be done to accomplish the change of use of this building. This is the work of a code specialist, a code consultant, working in tandem with the architect and the Department of Buildings, not this board. Finally, this is obviously a legalization. You can tell that because of the sign out front of this building. So fire department and Department of Buildings should inspect if they haven't done so already, and I don't find any violations for this use against this building. And of course, you know, as the caveat, when it's safe to do so for the health of all, I don't know that this, well, actually this operation may be operating because it's a refuse entity. So it's probably working currently, and it shouldn't be doing that in a building that is designed for residential use. So now I'll go to Commissioner Shanda.
Yeah, I have to say I had little difficulty following the application and also the narrative, especially with regards to the zoning lot. I don't know whether it is one zoning lot with 2 tax lot, which is subject to be subdivided. And does that then change the way DOB reviews them, or can, so because that was mentioned in the application, it was not very clear. Then also the subject building has a structure that joins the existing 1-story warehouse. And for a good portion of the building, or for some portion of the building, it's not shown in the plan. And I do not know if that then changes some of the review, like will BC 706.1.1 regarding party wall, will that apply? So as you mentioned, you know, this is really a thorough review that needs to be done by someone who is very well versed with the DOB codes and all of the analysis. I looked through it and I was trying to piece them together, but I think we need a much more vetting of experts before it comes to us.
Okay. Just one second. Okay, Commissioner Otley Brown.
So I think that the application has not been very thorough in what they're actually seeking to do. It seems to me from reading that they need to ensure that the building is up to date with the latest fire prevention measures as per the 2014 building code. However, it would be helpful if they also discuss this with the fire department, because I would like to see the fire department's view on it. For instance, when we've seen the requests for enlargement of building tenements, usually the applicant is working hand in hand with the fire department to ensure that whatever is proposed is going to at least ensure the same amount of safety as what's required in the code. So I would like to see that kind of working with the fire department as well as the building department here on this application, because I don't feel like we're fire safety experts.
Right.
And then also the other question I had was, they're putting the sprinklers in, but why no fire alarm? There should be something that alerts the office applicants that they need to get out fast. And so then the other question I also had was, if you're trying to upgrade the fire safety of the building by having enclosed existing stairs and non-combustible stairs, why are you retaining the wooden decks that are on the third floor? That seems like that's going to exacerbate any situation with fire if you have combustible wood decks. So those were my questions, basically. Oh, also one other question. Would converting to an office use require them to look at the strength of the structure to support any additional loads? That was just a question.
Okay. Right. Okay, thank you. Commissioner Sheta.
Thank you. First of all, I start with the plans. The elevation views are referred to as right, left, rear, and front. I would like them to make them north, south, east, west, like an architectural drawing does. So no right and left, just north and south and east, the directions that we know. The second thing, while reading this application, I was actually like a bit confused. Sometimes I feel like this is an appeal, and sometimes I feel like this is a variance. They are talking about interpretation of a code, which I'm not sure if we have jurisdiction to look into the building code. And this is kind of an appeal for me. But then they switch and they talk about, yeah, the building is in good shape. We don't want to demo the building to abide with the fire requirements. So we do have a hardship. So I'm not sure. But they are referring to past practice from the DOB dealing with similar cases. Like the chair said, they didn't mention any like precedents. If they can provide us with some examples, that would be helpful. And if they are talking about demoing the building or doing whatever is going to cause them hardship, I would say I would look at this and say why this is not a self-created hardship. I feel like it is. So they need to address that as well. Regarding the structural capacity, of course, that structural design requirements for an office building are different from a residential building. The loads may be like a bit higher, but I'm not sure if this should be like the first concern we look at. It's the role of their structural engineer to check that, but before we want to make sure that we have the jurisdiction to look at it. And like I said, I feel like this is a self-created hardship.
Yeah. And I just want to throw in that I'm aware of unusual kinds of buildings that in fact one, it was the residence of a famous artist. And they wanted to turn that into a museum. And the artist in his will said that when this is turned into a museum, I don't want anything changed at all. So you can't turn this into something that's this like fireproof building with fire stairs and all of that stuff. So the not-for-profit group that owns this structure and the museum worked with the Department of Buildings to come up with a solution where the only kinds of changes that were made to the building were hidden changes that a visitor would not be aware of. So the Department of Buildings has huge authority to modify the code. It has the authority to vary the code, but you have to negotiate with them. If I do this, what if I do that? And then the buildings department says, well, maybe if you give us a rain screen or something like that. There is no indication that they ever went to the buildings department to try to find out what would be acceptable, because it's not that buildings is an unreasonable place. They're willing to work with you. And this just seemed kind of cut and dry. We applied, they said no, and we came to you.
Well, they did resubmit, according to Todd, he sent me an email on March 5th. They resubmitted again documentation to the Borough Com, I think.
Yeah, but it seems like all they submitted was they wanted to get to the names of 2 sections of the building code that need to be varied because they never, by us, because that wasn't in the initial application. In the initial application, it says you have to comply, whatever, that you're not an exception. So therefore they have to come to us because they're not an exception. And then they went back to the buildings department and they got these 2 sections of the building code that are cited without doing any negotiating. It seems to me that they're just unwilling to work with a code consultant who would sit in the room with the buildings department and actually work something out. So I'm going to recognize Commissioner Shibeta now.
I was very confused by the application. Seems like that is true of the other commissioners. I would like to hear from the fire department about what they think is appropriate, but I'm not really sure. At this point, I'm not really sure what the appropriate relief is, if any, for this application.
Okay. All right. Thank you.
Okay, everyone, that's everyone, right?
Mhm.
Okay, so now we will commence with the actual public hearing
Mhm.
for April 6th, 10 a.m. session. So the first item to be heard is 11594 BZ, 2470, 2480 Bedford Avenue, Brooklyn.
Okay.
So this means the applicants only call in for this case, who are, sorry, the only people calling in would be the applicant for this case, 11594 BZ. Or zooming in or whatever.
Right. So,
And the ID number and password and phone number are on the screen right now.
and if you are not, if you're not calling in for 2470 Bedford Avenue, 115-94 BZ, hang up. It's a public hearing, only call in for your case. I
Firm
actually,
of LaBelle should be calling in.
Yeah.
Excuse me.
And Mr. Glenn Catron is the architect of record for this project.
Oh, sorry. Thank you, Carla.
okay, so the way this is appearing, I can't see, if you could admit Glenn Catrona.
Yeah.
There we go. Hi, state your name, please. Mr. Catrona? He hung up.
No, he's there. He's there. Glenn, are you?
Oh, okay. Hello.
Morning, Tony. Good morning, everyone.
You need to
Morning.
speak very loudly.
Okay, terrific. David Rosenberg is supposed to be joining us here.
Oh.
So,
Maybe you give him a call.
and potentially the client. Give me a moment. Sorry, I lost the YouTube stream there for a while, and that's why I joined in early. I apologize. 1 second.
Says the meeting is locked. David Rosenberg said meeting is locked. Is that possible, Kurt?
Yes, he should call in now.
Okay,
Yes, I'm getting, I have David on the phone. That's what he's actually saying. The meeting's
Yeah.
locked.
call in now.
Call
Call in
David.
now. I got it. I got it. Okay. Okay, anybody else? Okay.
Great, there's David. There he is. David, speak. Say your name.
I have to swear people in. Hurry up.
He's been admitted, so I'm not sure why he's not speaking. Mr. Rosenberg,
It
speak.
looks like his audio is connecting.
Yeah, looks like my audio should be in. I apologize for the technical difficulties.
Okay, please make sure that your YouTube is turned off.
Yes, it is.
Okay. Okay.
Go ahead.
So is that it, or can we swear them in?
Is there an iPad in the waiting room? I think we have the applicant.
Pad was, okay. No, not at the moment. Maybe you give him a
All
call
right.
in.
I will shoot him a, so the message that I'm getting from him is that the meeting is locked again. I will send him a message to log back in.
I don't see the meeting being locked.
Yes,
Okay, there he is.
all right. Okay,
Hello?
I think we have everyone. Yes, that is the applicant.
Okay, great.
Hello?
Yes, hi.
Okay, please state your name.
Hello? Howard Kazanowicz.
Okay, you're the property owner?
I am representing the property owner. That's my mother-in-law, Irma Paretsky.
Okay. All right, so
And my
everyone I have,
son-in-law.
okay, so I'm going to swear you all in. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
I do.
Yes.
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 Okay, please proceed.
All right. Good morning, everyone. I hope everyone is doing well in this. Our office was attending for the board's review session this morning, and I just want to address some of the, David Rosenberg, Sheldon Mobile PC on behalf of the applicant, wanted to address some of the preliminary issues that the board raised in the review session before talking about some of the larger issues. With respect to the dumpster that the chair raised in the photo submitted, I believe it's page 3 of the photo packet submitted, that dumpster, as well as the sign that's projecting over the screen, is located outside of the subject property. The applicant's building is lot line to lot line, and this dumpster and sign are located outside. This photo is just showing the work that was done at the behest of the board to repair the facade a bit and make it look more presentable for the community.
Before you go on with that, I know the dumpster is outside the property line. Whose dumpster is it?
It is not ours. I don't want to speculate to say whether it belongs to the neighboring automotive use or not, because I just don't have enough information to speculate to say that, but I can say that it is not ours.
Okay.
As we'd mentioned in the previous hearing, this particular automotive site operates. One automotive site has subsequently been filed for demolition permits and for residential construction, and the other is still active, but this one operates pursuant to the jurisdiction of the board. in between two others that have historically not operated under the board's jurisdiction. So I cannot speak to those sites. All I can say is that the dumpster itself does not belong to the applicant here and is not in our control. With respect to the other question of the board with respect to continuous use, the spreadsheet that was submitted to the board was a record from data from the New York State Department of Motor Vehicles. These kind of auto repair sites, such as the ones operated by the tenants of the applicant, are required to have various licensing from the Department of Motor Vehicles. And so what was submitted to the board was showing a record of the continuous active licensing of use group 16B automotive uses at the premises for the duration since the board's as far back as the DMV records go through the present. If the board wishes to see street view photos of the site historically, we can provide those, understanding that the reason why we did not submit those is that they show some of the images, depending on when they were taken, show the site in states of non-compliance with the previous grant. We appreciate the board's recognition that despite the previous condition at the site, the applicant has made significant efforts to ensure that there is compliance here. And we're willing to submit those, as well as the photos of the interior condition, which includes the tire racks fixed to the walls of the existing building. Those photos exist, including since the initial submission to the board of this particular set of site photographs, the awning for the Rendy's Auto Builders Incorporated has been swapped out for something that is more consistent with the rest of the site.
With respect to the continuous use, you can't show us a chart that you type yourself and say that it represents licensing without showing the licenses.
Well, as we note at the bottom of that chart, we show the link to the open data set that shows it. But we're happy to show as well the photographs from Google Street View that show the businesses at the site for all the intervening years without an issue.
Sorry, it showed the what?
It showed the continued use of automotive uses at the premises.
No, it was so all we received was a chart.
Yes. And so the chart, to be clear of what it shows, it's not just a chart that was created of our own invention. At the bottom of that chart is included a link to a data set from the New York State Department of Motor Vehicles that shows active business licenses located at the premises. But we are more than happy to submit street view photos that show active automotive businesses at the site for the duration since the last grant.
Okay, so but just to be clear, what we received was a PDF, an inactive PDF. So there isn't a link that gives us a data set of anything. That's why none of the commissioners found that there was any backup. So to be clear, all we got was an inactive PDF. And so that's why we're not aware of any backups, just so you understand. As far as
we will submit whatever backup information is required to substantiate the PDF, as well as photographs from Google Street View showing the continued use.
Okay.
And so I think that the larger issue, I think, judging from the review session, is that the board's assurance that what we say that we have done and what we're going to continue to do is going to be complied with, understanding the board's concern over the history of the site. Howard Kazanowicz, a representative of the property owner, is on the line to talk more about this. I think as the chair recognized, our efforts have shown that we are committed, especially after the last hearing, to make sure that this site is 100% compliant, entirely beyond reproach. And that is something that the applicants are committed to doing without question. Insofar as the board needs additional assurances, we're happy to discuss those further. And with respect to particularly Commissioner Otley Brown's concerns about what the police department has said regarding this. As the board noted in the review session, we did submit the street tree request, a copy of which we will provide to the board. Our options here are obviously limited. We are more than happy to accept as a condition of a grant that in the event the Department of Parks and Recreation does not decide to provide a tree here, that we will request a revocable consent from the Department of Transportation to put benches that will allow us to put benches on the sidewalk that will further inhibit the ability of cars to park here. But we are limited in that respect of our ability to take action on what is the street to restrict cars on a permanent basis, other than the temporary bollards that can be put on during business operation and taken off as they go along.
Okay, I'm going to recognize Commissioner Otley has her hand up.
Yeah, I just wanted to say that my comments aren't solely about the use of the sidewalk. So it's still going to be a problem, even if you do have the street trees planted on the sidewalk, because my comment also goes to the spillage of your business out onto the street with all of the cars that are parked without license plates on the street that are actually stopping residents from being able to utilize the public parking on street like they should be able to in every neighborhood. So it's not going to be solved by simply putting bollards or trees or benches on the sidewalk. And so that's a concern of mine.
Entirely understood. And with respect to the dead storage of vehicles that are not licensed on the street, which I think you're referring to.
Yes.
I've been on the site and have spoken with the neighborhood community officers of the 70th precinct, which, by the way, I happen to live in, and have spoken with them about this. And my conversations with them have indicated that this is not, in fact, related to the applicant's use. Insofar as that differs from the information that the board has, I'm more than happy to look into and address that both with them and with the applicant. The nature of the kind of work that the applicant does on site, compared especially to the neighbor to the north, does not generally involve the extensive body and mechanical work that would relate to the storage on the streets. I think that the representative of the applicant is on the line, and I think we all agree that the parking of those vehicles is absolutely unacceptable. And after this, I will reach out to the district manager of the community board and to help facilitate the conversations with the police precinct to determine what the issue is. But it's not something that we want continued, period. And it's something that we will absolutely stop. Understood that the street trees and potential benches are not something that addresses that issue. That's something that, it's a separate concern, and the residents' parking is something that the applicants understand and are prepared to do whatever it takes to provide the board assurances that they are ready to correct.
Okay, so but the community board doesn't agree with the statement. The community board's comments were specific to this site and said that there's body fender work and spray painting being done on the premises, and that the operations are extending beyond the time commitment, et cetera. So those are things that you can actually observe about the site specifically. And you can certainly, if you're a member of the community, observe whether the worker who's working on the street or on the sidewalk is going back into the shop as opposed to down the street to the adjoining shop. So not sure how you're going to address that. As Commissioner Sheta said, this is not the time period we're going to be able to address it, but you're going to need to come up with some kind of a plan that, and I dare say, probably even a restrictive declaration that's recorded against the property, so that at least there's some teeth that agencies can use to commit to proper behavior, because obviously the community board and the police department have a lot of reasons to be upset with this operation.
Madam Chair, I think that a restrictive declaration is something that the applicant is certainly open to, whether or not the enforcing party is the board or community board 14 or both, or whether or not this is a matter of understanding that the extension of term here can also be subjected to compliance hearings in the duration of the term. I think all of those are things that the applicant is prepared to do to show its commitment to making sure that the site is compliant.
Well, in addition to which, an extremely short leash. So
Understood.
client should understand, I know he's on the phone, your client should understand short leashes mean that you come back in a year and you had to have in incredibly good behavior during that time. If not, you come back in another year and the property owner realizes how expensive it is to come back because of the consultants that need to be hired in this case, right? And filing fees. Okay.
Understood that, a year may be, considering that the financial concerns of my client, a year is a lot, but understanding that the board needs to ensure that compliance is ensured, I think that, as the applicant are prepared to accept such conditions as the board may see fit to allow this to continue.
Okay, and Commissioner Shanda's hand is up.
Yes, and I see Mr. Glenn Cretona also wants to speak. But what I wanted to add to it, I think when we get to the point where we are deciding of in terms of the short lease, I would think, given the current condition that we are in, 1 year may be not reasonable. Maybe we do it a 2 or a 3 year, because this may be a long cycle. And by the time the applicant gets out of it and gets to some sense of normalcy of operation, we want to see how the use really operates in that normalcy. So 1 year may not be a reasonable way to guess it, maybe 2 years in the first go around.
That assumes moment that we were actually closing it today, which we were not.
I agree. That's what I said. We are not there, but should we get there 1 year? That's what I'm just putting that out there.
Now, if when we start the clock, all the coast is clear, then a year is enough. If the coast is not clear, then we compensate, right? So,
I think that the applicant understands the board's concern and the prerogative there of the board to make sure that these conditions are complied with, and it's something that we would accept.
Okay. And Mr. Catrona, did you want to say something?
Yes, good morning. I'd like to say a few things, just like to shed some perspective, okay? We hear the board loud and clear, not looking to defend any conditions that are out there, whether it be in part to others or this particular site. I've been involved with these people for a good number of years now, and the father used to run this here with multiple subsequent extensions of terms over the years, which were granted historically, as we all know. And he passed on. So now the wife takes over and was not really clear about what the procedures were. I think that there was a time there where there may have been a little bit of too much of a leash, and people renting took advantage. But I will tell you, over the course of time working with these people, I think that the owners have heard loud and clear what the requirements are, and the fact that it's a privilege to be granted a variance to have a use, a non-conforming use. But I think that they've seen and heard loud and clear. I've been on the phone a number of times with Ms. Sean Campbell over at the community board, the clarity of where these issues were actually coming from. And I will tell you that I've spent a lot of time going back and forth to this site and watched them make these improvements. In fact, I witnessed firsthand all of the tire racks bolted to the walls, the cleanliness of the site. The current person who's running Bedford Tires, who actually was at the hearing last time, has an amazing pride with what he's doing. They cleaned up this site. I had suggested some paint colors, and well, not picture perfect, but they did an amazing job cleaning up the facade, the exterior of this building. And yes, indeed, I do understand the concern about parking on the sidewalk, but they did put bollards on there stating no parking. I have not witnessed 3 times that I went out there any cars on the sidewalk from that point moving forward. I think this owner and operators are seeing clearly what the requirements are. I will tell you, if we give them the opportunity to meet whatever concerns to satisfy the board. And also, you know, there's always a growing period in any situation in our life's experiences. And I think that they see this here loud and clear. We duly noted the concerns of the board. We will begin to put together the additional paperwork and define what it is that we need to do to ensure that they'll be good players moving forward. But I think we have a new regime here, and they really want to see this here variance, you know, be approved. And I don't think something which is unreasonable, you know, a very short lease, I think we can do what we need to do, whether it's a compliance hearing in 2 years. But I think we need to really look at the fact of how this has grown through this experience for the owners and the operators. And I'm actually pretty proud to be behind them at this particular point, because I think they're really making every effort to be good players. I went there right before the last submission because I wasn't clear if the building was painted, and driving up to it and seeing everything clean and nothing on the sidewalk, and you know, the improvements that they made, I think they're putting their foot in the right direction. So that's pretty much what I want to say, but we will, of course, support any of the concerns of the board moving forward. And I'd ask that you would consider that. Thank you.
Okay, thank you. Mr. Katsanowitz, would you like to speak?
Yes, I would. Hi, I'm representing my mother-in-law. And Glenn was very eloquent in explaining that my father-in-law passed away back in 2011. And while he was a great family man, great person, he didn't know how to really run these businesses. He worked for the city of New York with the Transit Authority for almost 30 years. And the site was definitely not managed, I should say. He passed away in 2011. I have basically been involved with the property for the last a year and a half. We had a deed transmission that we had to forcibly remove from the property by eviction notice because how poorly it was run. There were cars all over the sidewalk at that point. We did eliminate that tenant. In respect, I just want to segue into something quickly. In respect to the body work, I know that the community board is stating things are being done out of 24/70. But that is absolutely incorrect. I visit the site weekly. We have no provision for a spray booth. We have no body work materials such as Bondo or sandpaper on the premises. So I'm going to reiterate that it is the building to the adjacent right of us, if you're standing in front of it, that has been doing the body work out of that location. And they do park on our property, and they do clog the streets up with these cars that we have no control over. And we have contacted the police, and the response from the police was, you know, they can't tow the cars. We've explained that to them. I visit that property since our last meeting weekly. I'm inside the building, which is Bedford Tires, to make sure the tire racks are secured. I go into Bedford Diagnostic next door to make sure they're operating correctly. And I've been very involved in it. It's the easy way out for my mother-in-law to sell the property, reap this big number, and move forward. We are considered by the governor of the state of New York an essential service. Nelson is in there working on his own, fixing tires, repairing cars, when he doesn't have the money to support a salary, to pay his 4 or 5 employees, to serve the community. There's nothing else open in that area to fix vehicles right now. There's not a repair shop open at this point. They're home. They're worried about their families, their own health. But Nelson, who's the tenant at Bedford Tire, is working the operation himself. So is Ray next door at Bedford Diagnostic. They're not making any money there with 1, 2, 3, 4 cars a day, but they're an essential service. They understand they're an important part of this community for over 40 years. While we might have not run it properly, and I do agree, I wasn't involved at that point. It's a different world now than it was 40 years ago when my father-in-law was running this. We are an essential service, and we are open during this trying time where everything around us is closed, including the car dealerships, which I service. So we are an essential part of this community. We supply affordable automotive repairs as well as tires and accessories to a community that might not otherwise have this available to them. They'd be forced to new car dealerships, paying $140 an hour labor. So while we're not the absolute ideal tenant, I guess, for the city of New York, we sure are trying to be so. And you have my word, and this is the way it will go forward. I've been there every single week. There are no cars on the property, nothing parked on the street. There's no need to. They have more than adequate parking inside of their buildings. I sent the picture over to Glenn and to David. I was there on Friday, demonstrating that the business is opened. Nelson can be seen in the building working on cars by himself, and he's afraid for his own safety. But he is considered an essential service. He is open during these trying times. I think that says a lot about him and his work ethic. And this is not simply about making money. If it was so, the family would have sold this building 2-3 years ago when it was at its prime, reaped the money and moved on. We're there. We've been there for 40 years. And with the permission of the board, hopefully we'll be able to continue. I thank you for your time.
Thank you. Thank you. Okay. So I think that the comments from the board were clear. We need to figure out an operational plan so we can make sure that what Mr. Katsanowitz represents today is the case over the next year, assuming things return to normal shortly. So relatively shortly. So we do need that from Mr. Rosenberg and Mr. Catrona and the other issues that were still unresolved. Okay.
So we can submit the information requested by the board probably today, if not within the next 24 hours.
No. Slow down. We don't have a schedule where it rolls really quickly. We will let you know what the continued hearing date is and what the submission date is. Okay. So on these kinds of hearings, we don't negotiate a new date. We will assign a date to you. All right.
Understood.
Okay. Okay. So then thank you very much all, Mr. Catrona, Mr. Rosenberg, and Mr. Katsanowitz for calling in. We do appreciate it. Are there any other members of the public who would like to speak on this? If so, please call 646-558-8656.
Be safe, everyone.
Thank you. You too.
Take care. Okay, Tony, you can.
Well, the next one. Item number 24503BZ, 16011 Willets Point Boulevard, Queens. The applicants for that case, please call in. I think Marie had called in before.
Yeah, she called in during the review session. And Mr. Catrona, please hang up.
I'm trying my best here.
You have to end meeting, lower right-hand corner.
I
And
got it. I keep clicking it.
no,
All right. We'll get through this here. Thank you.
thank you.
Take care, Glenn.
Bye now.
He has to have his tech expert hang up.
That's Mrs. Catrona.
So this is 160-11 Willets Point Boulevard, 245-03BZ. Seyfarth Shaw is the applicant. Please call in. And by the way, that's the only person or only application who should be calling in.
Do you want a second call it or something? I don't know.
No, because it does take time. I know we have like a 20-second delay. Can somebody give her a call, maybe?
Oh, I don't have her number. Let's see. Let's see if I have her
Members
number.
of the applicant team have been admitted.
Oh, they have?
Yes.
Okay. I can't see that one.
At the top, if you click manage participants, it will bring up the list of people.
Oh, it shows up again. Oh, I see. Oh, look at that. Okay. So I see Nicholas Alexiadis is in. And Maria Papet, however you pronounce, Papesevatos is in. But I don't think her audio is on. So, Mr. Alexiadis, do you want to announce yourself?
Yes, one moment. Okay, so can everyone hear me?
Yes.
We could see you also.
Okay, perfect.
State, please.
So my name is Nicholas Alexiadis from Bowler on behalf of the applicant.
Okay, so
Civil engineer.
we just need to get Mr. Alexiadis. Do you want to announce yourself?
Maria, turn off your YouTube.
Okay, is that better?
Yeah, thank you.
Your name, please.
Nicholas Alexiadis from Bowler on behalf of the applicant.
Maria, identify yourself.
Maria Papasevastos from Cyfroth Shaw on behalf of the applicant.
Okay, let me swear you in. Do you affirm to tell the truth? Raise your right hand.
Sorry, Tony, we should be having Juan Reyes log in.
Oh, okay. Okay,
If we could just give him 1 minute.
okay.
I can call him as well.
Give him a call because, yeah.
Also, the owner should be joining. Let me see what's going on.
We need to move these cases along. So.
Yeah, it takes a long time for these things to connect, unfortunately. There's a long delay.
Yeah, I apologize. That's why I had called in earlier. I wasn't able to view the YouTube and got concerned. So apologize.
Okay, I think we should just move on and Mr. Reyes will call in when he calls in. Okay.
Okay, so can I swear you guys in? Raise your right hands. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and respond on the city board member questions?
Yes.
Okay.
I do.
Okay.
Okay, so we listened in this morning to the review session. We understand the concerns about landscaping and the additional parking sign, the sound specifications. The engineer on the line is Nick Alexiadis. He's going to be able to kind of go through those points with you. Just an initial note, I want to assure the board that we're not intentionally ignoring any requests for anything that any request that's been made by the commissioners, and our engineer will be able to explain our reasoning for what we have included. So with that, I'll turn it over to Nick.
Thank you. So I'm just going to go through the comments from earlier this morning, one by one, as they were raised. The first one was for a sign for parking in the rear to identify to the incoming traffic that there is additional parking available to them. As you can see on BSA 002, we do still have the parking in the rear sign as you enter the driveway from Willets Point Boulevard.
Yeah.
However, the additional sign that was to be mounted on the new trash enclosure that had since been removed due to the discussions previously about the change in grade and not requiring additional trees in the rear area, the existing trash enclosure is to remain. Should the board request it, we have no objection to adding the additional sign on that trash enclosure, and we can make that change on the plans and resubmit. Is that something that we should include?
I don't actually understand why the sign was removed from there. The whole point was that people don't know that open space between the trash enclosure and the planting leads to the parking and additional parking. So that was the whole purpose of that. And so yes, put it back on the trash to direct people.
Okay, so to confirm, we'll have the dual signs, the one as you enter the drive-through and the one mounted on the trash enclosure.
Yes.
Okay. As far as the planting bed width, we are going to modify the curb line to facilitate a 4-foot internal planting bed dimension for the additional 5 arborvitae that are being proposed in that area. I believe there was some modification done during the determination to leave the existing fence to remain and mount the acoustical material to that fence. So we will modify that curb line appropriately to incorporate that buffer.
Okay, so what's confusing is you have a site plan that doesn't dimension the planting bed that is on the side against the acoustical fence. It only has one dimension there, and then it next down to other dimensions. You need to dimension it to show that you are compliant with your own detail that says the minimum dimension is 4 feet, right?
Yep. We will modify the plan to be more clear. We're going to add additional dimensions to that area. We were under the impression that the section would be a typical section BB for that area to direct the contractor that there would be a 4-foot minimum maintained. However, we're going to clarify that with some additional dimensioning.
Okay.
I think Mr. Reyes is in the room. I see Say Visitor.
There's someone called Say Visitor. I don't know whether that's.
That might be one.
Yeah, it's my law firm, Safe Arth.
Ah, okay.
Oh, sorry about that.
Okay.
It's a firm computer.
State your name, please.
Juan Reyes, Safe Arth Shaw Law Firm.
Okay. All right.
Let me swear you in, Ron. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
I do.
Okay.
Okay, continue, Mr. Alexiadis.
So the next comment was the providing a section detail through the drive-through showing the plants. I believe this is for the plants that are being provided to the left of the drive-through, adjacent to the building. And I believe this comment also segued into clarification of the container designation on our landscaping schedule.
Mm-hmm.
So we're proposing that these plants are to be planted in planting soil. The container is the size designation at planting that we are proposing due to, for the contractor to utilize during construction.
Mm-hmm.
But all of these plants will be planted in planting soil. Would it be possible to provide a note on the plan that all plants, irrespective of their planting designation, are to be planted in planting soil? Would that suffice in lieu of the additional section?
No, you need a section to show what it is you're going to do with that planting bed, because unless that planting bed looks like detail, I guess it's BB. If it looks like detail BB, then show that it's also section BB. Otherwise, it's a mystery what it is, right?
Understood.
Okay.
Yep. So we'll provide an additional section through that area, showing the row of plants to be provided.
Okay. So, and the idea is that the planting bed is deep enough so it can support permanently the plants that are taken out of the containers and put into the planting bed. So I don't know if that's a 3-foot deep planting bed. It depends on what kind of shrubbery it is.
We'll confirm and provide the appropriate planting depth on the section.
Okay. And of course, there must be a curb all the way around, right?
That's correct. There's a curb on the right side of the planting bed, and on the left side is a concrete pedestrian walkway.
Okay.
And lastly, a topic that we had discussed at length at the last meeting, the sound propagation. So based on discussions with the manufacturer, we were not able to obtain additional information for sound at different levels. The sound information provided is at the level of the speaker, and the hatching and sound exhibit provided on BSA 010 reflects that information. we have added additional notation that the maximum output of the speaker in any circumstance is limited to 57 decibels by a control system. And based on our decibel comparison chart that's provided on the same plan, you can see that ambient noise is just around that, if not significantly higher than what we're providing. And therefore, any sound at the property line would be less than the ambient noise in the immediate area. In addition, with the sound at and above the sound attenuation material being at ambient noise, we're also providing the planting row of arborvitae to further minimize the sound that would be propagating over the fence. And that was our judgment, was that in providing these trees and the acoustical material, that the sound propagation over the fence would be limited and would most definitely be under the ambient noise of an area typical of this development.
I don't understand why you can't get vertical information. That makes no sense. We've gotten it from other manufacturers where we see how the speaker propagates vertically. And in fact, on another case we had very recently, it was decided that because the sound travels too vertically relative to that structure, that they moved the speaker in the housing. It was outside of the housing. They moved it into the housing, and then they did an analysis and could determine that the sound doesn't propagate higher than kind of the height of the top of the car or something like that. So it makes no sense that you can't get this information. They test this, it's known. I'm going to recognize Commissioner Sheta, who has his hand up.
I totally respect what the applicant is saying, but sometimes it's not just your judgment. Your judgment should be backed by some technical information. And apart from this, what is the difference between the shading that is submitted this time and the one before? Is there any technical difference other than just cropping what is to the right of the fence?
No, the data that's provided on the plan is from our sound device manufacturer. We merely just cropped it, as we had discussed last time, to show that there was no propagation beyond the acoustical deadening material at the level of which the study was conducted.
But that's even not true, because if your noise reduction rating for the fence is 25 and you're getting left of the fence, you're getting 50, right of the fence, you're not getting 0. You should get 50 minus the rating, the reduction rating, which is 25. So you should get 25. And that wasn't done last time. And when we started talking about the vertical propagation, and we asked for something at the top of the fence, like the fence is not there, give us the reading at the top of the fence. If it is satisfactory, we'll take it. What is just done this time is actually submitting the same exact thing that was submitting last time, but just hiding what is to the right of the fence. And that's what we didn't ask for. And it's wasting our time, actually. I don't know why, if you have the intention to submit something like that, you could have just alerted us. We're not able to do the vertical propagation thing. Please take a look at the same what we submitted before, and right of the fence, it's not going to exceed this. But to submit this, and I spend time looking at it, trying to figure out what is submitted, that's not helpful.
Okay, in regards to the comment you had brought up with the decibels to the left side of the fence, I'd like to direct your attention to the menu board sounds legend that's provided on that plan, which, as indicated by the green shading, the device produces 21 decibels at the property line where the acoustical fence material is being provided. And the acoustical fence material is capable of a reduction of 28 decibels. So therefore, at that level, there would be no sound propagation. So there's no trying to we're not trying to hide any information. The data that was provided by the manufacturer and the data that's provided by the acoustical material manufacturer suggests that there should be no propagation at that level. In terms of the level
What
of
level? I'm sorry. Let me interrupt you. At what level? It shouldn't be any propagation at what level?
4 feet, as indicated by the note that we have on that same plan, that the speaker measurements that were provided by the manufacturer were at 4 feet above grade. And they also assume 0 obstructions between the speaker and the measurement device. So there are many real world circumstances that will affect the readings once these are actually implemented. But bear in mind that this is a new installation, and every installation has its own caveats and its own characteristics that can make the data different from one installation to the other. And based on the information that we have available to us, we're trying to make the best representation we can on the plan of the conditions.
So you're measuring, this is the part I don't understand. It measures at 4 feet. What's the measurement at 9 feet? Sound travels in all directions unless obstructed, right? So why, unless you locate the speaker in a housing that prevents it from traveling higher than the car, the sound will continue to travel in a straight line on an angle, right? And so you don't actually provide us with that. How do we know it's not louder at the top? And I don't believe that the manufacturer doesn't have this information. And that makes no sense, just like lumen spread diagrams. So you need to go back to the manufacturer and say, I need a vertical section through the propagation. We've seen this in other cases.
Yeah.
So it can't be that it doesn't exist. It's sounding more to me either like it or you haven't asked them. We have it in other cases. And in those other cases, as I said, they had to adjust the location of the speaker. I'm going to recognize Commissioner Shanda, who has her hand up.
I had a very basic question, but I'm looking at BSA drawing 10. In that, the legend says sound level up to 45, AVC off, and then it says sound level up to 21, AVC on. What is AVC?
AVC is the automatic volume control on this particular speaker, which limits the sound projection to a maximum of 15 decibels above the ambient noise at the time of which the speaker is being utilized. So it's
the different. Sorry, go ahead.
No, I'm sorry. It's a sound control mechanism.
Okay. So the difference in all of them should be consistently 24? On and off?
It's based on the level at that that point. I believe it could vary based on the ambient level.
Okay.
Okay, Commissioner Otley Brown has her hand up.
Looking at the BSA 0080, which shows the whole menu board and the speaker system, isn't the speaker in the housing already?
That is correct.
Mm-hmm.
That's what I want, because I remember in the other case, it was an older model speaker system. So the speaker was initially on the outside, just sitting there like a speaker. And then they moved that into the housing. But this case is a modern menu board speaker system that actually has the speaker in that metal, I guess, I don't know what you would call it, beam or whatever that is.
Mm-hmm.
That is correct. This is the most up-to-date speaker system that we've been proposing on recent projects.
So then you have a lot of data on the speaker. If you've been using it on recent projects, it's easy for you to determine what it is. Go measure it.
We have requested that information from the manufacturer, and it was unavailable to us.
No, you can go measure it.
Like I said, every situation is different. So sound data from one site might not be the same as the other site because of the ambient noise characteristics of any particular development.
No, but so I'm not talking about the ambient noise. I'm talking about the sound that is emanating from the speaker. If you set up a speaker, that's how they do modeling, right? In a laboratory situation, you turn the speaker on, you have somebody order a hammer, you see how much it is, wherever it is, and then you measure the sound during that time at different distances, and we're specifically interested in heights, right?
I completely understand that, but what would happen, say, for example, if we did this study at a typical McDonald's in a New York City street, and you have MTA buses driving down the street, you have a police car going down Francis Lewis Boulevard, you know, the ambient noise, we could take measurements at any distance from the speaker. And basic studies have shown that that would be an ambient noise measurement. It would not be the actual measurement of the speaker. You would be reading the ambient noise of that area. So in theory, you should be getting a very consistent reading once you get past the level of ambient noise that we've determined for this area of.
So here's the thing. I'm going to recognize all the commissioners. Commissioner Sheta, Shanda, and Shibeta had their hands up in that order. What's going on right now is you're explaining why you can't do this thing, and we're saying we need this thing. So you need to figure out how to give us comfort that we don't have sound propagation above the fence, and you need to just figure out how to do it. It's not an impossibility. Science is much more sophisticated than what you're presenting, and I just think you need to move on and you need to take care of this thing. I'm muting Commissioner Sheta.
Yeah, I believe, first of all, I just want to make it crystal clear on the record that we've got this before. It was submitted to us before. Number two, there is nothing. I can't believe that there is something that couldn't be measured. Of course you could measure it. You could separate the ambient noise from the noise that's coming from the ambient plus any other source. You could measure with and without, and then separate the two effects. And for the vertical propagation analysis, I don't think this is a big deal at all. What I'm saying is you mentioned on the record that it's not going to be propagation beyond the fence. To prove that this is incorrect, all what you need to do is just take a look at your own plan and look at the green. The green says it's from 25, let's say, to 48. I'm going to make it 50 for simplicity. If it's from 25 to 50 and the noise reduction rating of your acoustic fence is 25, again, to make it simple, that means that you're going to have propagation past the fence of 0 to 25. This is going to penetrate through the fence because you, the one who mentioned that the fence could just filter out 25 out of whatever. If this is the case, we want to know at the top of the fence where the filtration of the fence is not there, how much is going to be passing through. That's very straightforward and simple. I'm not sure if you're I'm not a sound engineer, but I've seen it before. That's why I'm talking with that confidence. If you're not a sound engineer, talk to one.
Okay, so I don't much longer or a debate. This is an instruction, okay? So you need to take care of this. I'm going to recognize Commissioner Shanda.
I have no comments.
Okay. Okay. So yeah, so we're not debating this anymore. This is an instruction. Are there any other comments?
I think Mr. Reyes wants to speak.
I'm recognizing Mr. Reyes.
Juan? Oh, you didn't unmute him.
Oh, I thought I did. Okay, there we go.
There you go. Juan, you're on.
Okay, hi. I totally understand what you're requesting. You know, we had asked the Bowler Engineering to provide that information. This was their response. We asked them numerous times. I believe that they were being forthcoming. And as the case is, if that you're stating that this has been provided in other cases, then I will make sure that they get whatever was provided to you in other cases. I don't think that's going to be an issue.
Okay.
The only problem though is, at this point, the business is suffering. This hearing's been going on for a long time. We've been extremely patient. We've tried to provide everything. It's unfortunate that the sign wasn't on the last plan, that they didn't detail the landscaping as they should have. But these are things that we will address and will be done.
Move on. We can't spend more time negotiating this. You need to give us complete.
I'm not negotiating. I'm saying I'm agreeing. Okay, I'm agreeing. But we're just trying to get some kind of finality because the case has gone on for so long. Is if there's a way to close and grant this and provide it conditioned on that, and we get this information to you, the plan's probably today.
Stop. We don't do close and grants during this time period. And besides, your drawings are not ready. So had your drawings been ready, had they been responsive to our comments, had you gotten the information that we asked for or why we weren't getting the information we asked for, we might be in a different position today, but we're not. And we don't, under these conditions, do closed grants. So I don't want to debate this anymore, Mr. Alexiades. I think we're done with the conversation. Okay. And so we will I don't think there are speakers. Are there any speakers from the public anyone from the public who wants to speak on this? Okay. So then, so people from the public who may want to speak on this, 646-558-8656. And otherwise, we will let you know when the date is for the continuation. Please be very thorough in your submission. Listen to everything in this hearing and in the review session, and make sure 100% of the things that are requested are done, and triple check your drawings, because the drawings were in fact incomplete, and incomplete drawings slows down the process. Okay, so I think that's it for this one. So thank you for calling in. We appreciate your participation.
Okay. 6414 BZ, 1320 East 23rd Street, Brooklyn. I'm sorry.
It's 12:06. We're going to take a 10-minute break. Come back at 12:15. Okay. So 12:15, and we're going to, not sure exactly, how does this work? Kurt, you want to explain what happens to the hearing?
Yes, we should stop recording and stop the YouTube live stream and then resume after 10 minutes.
Okay, great. So 12:15, everybody come back. Okay, thanks.
So we just relog on, or?
Yes.
Yes. Okay. We hang up and then log back on. Okay, great.
Okay.
Thank you.
Lead meeting? Okay.